In Indian polity, we are going to discuss about Article 22, that is protection against arrest and detention. So total articles 22 clause 1 to 22 clause 7. Okay, so Article 22 is the last article from the second fundamental right, that is right to freedom. Total articles 19 to 22 articles deals about the right to freedom. Okay, so Article 22, it provides protection to persons who are arrested or detained. Okay, so the arrested or detained persons can enjoy this Article 22. Okay, so this Article 22 is applicable to the citizens and non-citizens also. Okay, it means citizens and foreigners also can get the protection from Article 22. Okay, so finally detention is of two types. First one is punitive detention, second one is preventive detention. Okay, so articles 22 clause 1 to 22 clause 3 deals about the punitive detention, and articles 22 clause 4 to article 22 clause 7 deals about the preventive detention. Okay, first one is punitive detention. So here punitive detention means to punish a person for an offense committed by him after trial and after conviction in a court. Okay, so the person who is committed an offense, okay, and he will be detained and he will be arrested, he will be punished, okay, after trial and after conviction in a court for his offense. This is the punitive detention. Okay, so if a person is arrested or detained under punitive detention, so these cases deals under the ordinary law. Okay, so if a person is arrested under punitive detention, the important case will be comes under the ordinary law case. Okay, so first article is Article 22 clause 1. Okay, so right to be informed of the grounds of arrest. So the person has the right to know the grounds of his arrest. Okay, and a right to consult legal practitioner. Okay, so and he has the right to apply for the bail. Okay, so this is the basic right of the person who is arrested under punitive detention. Okay, and second article is Article 22 clause 2. Okay, so right to be produced before magistrate or court within 24 hours. Okay, so within 24 hours he has the right to be produced in a magistrate. Okay, and here the journey time was excluded. Okay, and so right to be released after 24 hours. If not possible to produce in a magistrate or court, he has to be released after 24 hours. Okay, if magistrate said to continue the period, so they can continue. If not, he will be free after 24 hours. Okay, and third article is Article 22 clause 3. Okay, so it talks about Article 22 clause 1 and Article 22 clause 2. These two articles are not available to the enemy aliens. Okay, and the persons who are arrested are detained under preventive detention. Okay, so articles 22 clause 1, article 22 clause 2, these only applicable to the friendly aliens and the persons who are arrested or detained under punitive detention. Okay, so these two articles are not applicable to the enemy aliens and the persons who are arrested under preventive detention law. Okay, so second one is preventive detention. Okay, so articles 22 clause 4 to article 22 clause 7. Okay, so here preventive detention means detention of a person without a trial and conviction by a court. Okay, so without a trial and conviction by a court, he will be arrested or detained under preventive detention. Okay, so we can say this is a precautionary measure. Okay, and one more thing is this preventive detention is not to punish for a past offense. okay, and to prevent him from committing an offense in future. Okay, that's why we can say this is a precautionary measure. Okay, so meaning of the preventive detention is taking a person into custody, an individual who has not committed a crime yet, but the authorities believe him to be a threat to law and order. Okay, so before committing a crime, the person who has to be arrested or detained. Okay, so because the authorities believe him to be a threat to the law and order, okay, public order. Okay, so this is the actual meaning of the preventive detention. Coming to the scope of the preventive detention, so the power to make preventive detention laws in India, constitution itself. Okay, so the preventive detention power was given in the constitution itself only. Okay, and the constitution empowered the parliament to make such laws regarding the preventive detention law. Okay, so the legislative powers regarding the preventive detention were divided into two parts, one for the parliament and another for the parliament plus state legislature. Okay, so under the parliament point of view, the reasons for the making laws for the preventive detention are defense, foreign affairs and security of India. So these three are important features for the making of preventive detention law under the parliament. It means under central government. Okay, next one is parliament plus state legislature. It means concurrent powers. Okay, so both have the right to make laws for the preventive detention. Under reasons are security of state, public order and maintenance of supplies and services. Okay, so these three important features are very important for the making laws regarding the preventive detention by the parliament as well as state legislature. Okay, because this is a concurrent power. Okay, so this important preventive detention is an integral part of the constitution. Okay, so we adopted this important provision or feature from the Britain. Okay, so during the first and second world wars, Britain adopted this important preventive detention. Okay, in India we adopted this important preventive detention laws during the British rule, from the British period. Okay, for example, during the British rule, there is a act under so Bengal State Prisoners Regulation Act 1818 and Defence of India Act 1939. So these two are very important under preventive detention laws during the British rule. Okay. Coming to the articles of preventive detention, Article 22 Clause 4. It talks about detention of a person cannot be exceed more than 3 months. Okay, so detention of a person cannot be exceed 3 months, more than 3 months. Okay, this is the Article 22 Clause 4. And Article 22 Clause 4 and Subclause A. It talks about there is an advisory body for the extension of a period of the preventive detention. Okay, here advisory board consists of the judges of court. Okay, this is the Article 22 Clause 4 Subclause A. And Article 22 Clause 4 and Subclause B, it talks about Parliament has the power to extend his or her detention period and can make any new law regarding the detention. Okay, here entire power was given to the Parliament from the Constitution. So the Parliament can make any law regarding the preventive detention and it can extend the period of preventive detention. Okay. In Article 22 Clause 5, it talks about he has the right to petition against the government for his detention. Okay, so the detained person has the right to petition against the government. Okay, so this is one of the right fundamental right. Okay, and Article 22 Clause 7 Subclause A, it talks about Parliament can detain a person more than 3 months without obtaining the opinion of an advisory board. Okay, so without taking any opinion from the advisory board, the parliament can extend the period of more than 3 months. Okay, so this is the power of parliament. And another article 22 clause 7 subclause B, it talks about parliament can determine the maximum period of detention. Okay, so parliament can determine the maximum period of detention. Okay, and it can make any new laws for the extension. Okay, this is the article 22 clause 7 subclause B. And article 22 clause 7 subclause C, it talks about parliament can give a procedure for advisory board for inquiry. So the advisory body is going to inquire any case, okay, through judges of court. So the parliament can give a procedure for the inquiry. So this is article 22 clause 7 subclause C. Okay, so we already seen the entire power to make any law regarding the preventive detention was given to the parliament, right? So parliament, by using that power, it made several acts under preventive detention laws. First one is Preventive Detention Act 1950. Actually this was expired in 1969. Okay, and another one is Maintenance of Internal Security, okay, Act 1971, and this was repealed in 1978. Next one is Terrorist and Disruptive Activities Prevention Act 1985, and this also repealed in 1995. And Prevention of Terrorism Act 2002, this was repealed in 2004. Okay, and National Security Act 1980, Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974, and Parliament enacted Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act 1980, and Parliament enacted Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substance Act 1988. Okay, another act is Unlawful Activities Prevention Act 1967. So these important acts are made by the parliament by using the power which was given from the constitution. Okay, so A.K. Gopalan versus State of Madras, this is the first case which is related to the preventive detention law. Okay.